Hello and welcome to this Guildford Chambers webinar. My name is Laura Smallwood. I'm a barrister and member of the property team at Guildford Chambers. The webinar will last approximately 40 minutes. If you have any questions about the authorities covered, please contact me by email and I will respond. My email will be on the concluding slide. The purpose of this webinar is to take you through a clutch of landlord and tenant decisions from last year, which should have application in everyday practice. I'm not dealing with the obscure or the erudite, but with decisions which are useful additions to your L&T toolkit. So I make no apologies for the perhaps more pedestrian nature of the material today. The topics I will cover range from tenancy deposits, EPCs and Section 8 notices, to the test for a defended possession claim, contracting out of the 1954 Act, and waiver of forfeiture. I have set out the cases on the introductory slide. In each case, I will give the principle which the authority provides before outlining the statutory or other background and the facts. I will then summarise the basis for the court's decision and briefly consider the practical implications of each judgment. My first case is Sturgis and Body. This is a decision of His Honour Judge Luber QC in the County Court at Central London. I'm including it despite the fact that it is a county court decision because it deals with the consequences for landlords of the tenancy deposit legislation in a very common letting scenario, namely the flat share or house share. The summary of the decision is that a landlord is deemed to have received a deposit from tenants in a house or flat share on each occasion that there is a change of occupant. Thus, a claim for a deposit penalty under Section 2144 of the Housing Act 2004 arises on each changeover if the deposit has not been protected. The statutory background, of course, is Section 213 of the Housing Act 2004, which sets out requirements relating to tenancy deposits, and where these have not been complied with, Section 2144 provides for payment of a deposit penalty by the landlord of 1 to 3 times the deposit. The facts here then were that there was a flat share situation. The landlord let to 4 unrelated individuals on an AST in 2004. A deposit was paid. This was, of course, before the tenancy deposit requirements, but it was not protected at any stage. The tenants all had their own bedroom, but they shared the use of the other areas in the flat. The rent was paid by a lead tenant on behalf of the other tenants to the landlord. Changeover of occupants was inherent in the situation, and this was done by the tenants selecting the replacement and sorting out between themselves the reimbursement of the outgoing occupier for their share of the initial deposit by the incoming occupier. The landlord thus had minimal involvement in the changeover. And changeover of occupants was described in the judgment as a churn. There were subsequent churns of tenants, and by 2020, all the original tenants had been replaced. As the judge said in his judgment, all goes well until it does not. And in 2020, things did not go well for the landlord when 2 departing tenants claimed penalties under Section 2144 on the basis of a surrender and re-grant of the tenancy on each churn. The tenants claimed that the Housing Act required the deposit to be protected at each churn, and a penalty therefore arose on each occasion. The landlord defended on the grounds that the tenants were licensees. There was therefore no obligation to protect the deposit. But in any event, the landlord argued that as the defendant tenants had not paid the landlord any deposit, there was nothing to protect and no penalty could arise. The Deputy District Judge accepted the landlord's arguments and dismissed the tenant's claim. On appeal, however, the judge held that the tenants succeeded. He found that they were tenants. All the hallmarks of tenancy were present in the arrangement, namely exclusive possession for a term at a rent. And the judge accepted the tenant's argument that at each term there was a surrender by operation of law and a regrant to the new tenants. The landlord had argued that he was insufficiently involved in the churn for it to constitute a surrender and regrant. But the judge found that there was a prior arrangement between the landlord and the tenants as to the process of changeover, and it would be absurd to think that the landlord could insist that an individual who was a joint tenant before a churn but had left after it was still a tenant, even though the landlord was accepting rent that he knew was being tendered on behalf of a new group. In relation to the argument that the claimant tenants had not paid the deposit to the landlord, the judge applied the reasoning in Superstrike Limited and Rodriguez. He held that the landlord must be treated as having been paid the amount held in respect of the original and each successive cohort of tenants by each new group of tenants. The alternative, he said, was an indefinite liability to account to the original long-gone tenant, and that was completely artificial. The deposit for the purposes of the penalty was the amount treated as received and paid for the whole flat, not the particular tenant's smaller personal payment. The judge held that the landlord's argument that the liability was severable was flatly rejected. And the judge assessed the multiplier here at 1 times the remaining deposit because it had reduced over time due to deductions. He said that the case was at the bottom end of culpability, and he took into account the fact that the deposit was taken at a time when protection was not required, and the landlord had subsequently not believed that protection was necessary. Now, despite its limitations as a county court decision, I think that this is definitely a case worth being aware of. It is a cautionary tale for landlords operating these kind of informal house and flat share arrangements. There is the attraction, of course, of low input and minimal involvement for the landlord where there might be frequent churns. But the flip side is the possibility of large claims for statutory penalties in cases where there is a high turnover of occupants. The way to avoid these problems, of course, is with greater formality, i.e. re-protect the deposit and serve the prescribed information at each changeover. And as a final point on that slide, I've said, is this an issue for further judicial consideration? I query whether the fiction of payment of the whole deposit is correct or fair when only a lesser sum, namely the changeover tenant's share of the deposit, has actually changed hands. Rather than a surrender and regrant, would a better analysis be an assignment of the AST? The issue would then be as to protection of the initial deposit actually paid, and the landlord's liability would not be dependent on the number of churns. So I think there is scope for further argument on that issue. My second authority is Minister and Hathaway, and this relates to energy performance certificates and Section 21 notices. The summary is that the requirement to serve an energy performance certificate prior to service of a Section 21 notice does not apply to ASTs granted before the 1st of October 2015. It's necessary to spend a little time explaining the statutory background on what is a short point because of the statutory spaghetti of the Deregulation Act 2015 and the regulations under the Housing Act 1988. Sections 38 and 39 of the rather ironically named Deregulation Act 2015 inserted sections 21A and B into the Housing Act 1988. And the effect of those sections is to impose requirements which the landlord must comply with before he can serve a valid Section 21 notice. By Section 21A2, those requirements include requirements relating to energy performance. The Secretary of State exercised the power to make regulations under Section 21B by making the AST Notices and Prescribed Requirements England Regulations 2015, which came into force on the 1st of October that year. Regulation 2 sets out requirements which must be complied with, and subparagraph 1A is a reference to 2012 regulations which require the provision of an EPC. Regulation 1.3 of the 2015 regulations states that they apply to an AST granted on or after the 1st of October 2015. Now, the application of sections 38 and 39 of the 2015 Act, and so sections 21A and 21B of the Housing Act, is dealt with by section 41 of the Deregulation Act, which also came into force on the 1st of October 2015. And the effect of sections 41(1) and 2 is to limit the application of sections 21A and B to ASTs granted on or after the 1st of October 2015. So far, so good. But section 41(3) of the Deregulation Act provides that after a period of 3 years from the coming into force of section 38, not section 39, and I'll come back to that later. So on the 1st of October 2018, section 38 applies to all ASTs whensoever granted. Now, with apologies for that lengthy preamble, I'll move on to the facts. The landlords granted the tenant a 1-year AST of a flat in March 2008. The tenants remained in occupation after expiry of the term and became periodic statutory tenants in 2009. The landlord served a Section 21 notice in 2018. It was common ground that no EPC had been served, and the tenant defended the proceedings on the basis that the landlord couldn't rely on the Section 21 notice because no EPC had been served. In the light of my introduction, you can anticipate how the battle lines were drawn. The tenant contended that Regulation 2 did apply by virtue of Section 41(3 because the tenancy was an AST in existence on the 1st of October 2018. The landlords contended that service of an EPC was not required because the tenancy was not an AST granted on or after the 1st of October 2015. Now, the district judge found that the requirement to serve an EPC did apply, but this was reversed by the county court judge on the landlord's appeal. The Court of Appeal held that Regulation 2 did not apply here. There was no requirement to serve an EPC. The starting point was that the statutory periodic tenancy was deemed to have been granted in 2009, so it wasn't granted on or after the 1st of October 2015. The court held that Section 21A could apply to a tenancy in existence on the 1st of October 2018 by virtue of Section 41(3) of the 2015 Act, but it would only bite if the Secretary of State exercised the power in Section 21A(2) to impose requirements. That power had been exercised by making Regulation 2 of the 2015 regulations, which applies to ASTs in existence on the 1st of October 2015. Although from the 1st of October 2018, there was power to extend the reach of Regulation 2 to any AST in existence on that date, that had not been done. Therefore, Regulation 2 of the 2015 regulations did not apply to this AST, or indeed any AST granted before the 1st of October 2015. The important takeaway from this rather complex explanation is that the EPC requirement does not apply to tenancies granted before the 1st of October 2015. The cases welcome clarification as to the effect of Section 41(3) of the Deregulation Act 2015 because it had divided both commentators and judges. Note that the decision also means that there is no requirement to provide a gas safety certificate for ASTs granted before the 1st of October 2015. This case deals with Regulation 2.1a of the 2015 regulations. The gas safety requirement is contained in Regulation 2.1b, and no distinction can be drawn between the application of the two requirements. In case you're wondering about the How to Rent guide, it was never caught up in this debate because provision of the guide is required by Regulation 3 of the 2015 regulations pursuant to Section 21B of the Housing Act 1988. Section 21B was inserted by Section 39 of the 2015 Act, and Section 41.3, which applies the requirements to all ASTs from the 1st of October 2018, does not apply to Section 39. The next case is Northwood Solely Hull Limited and Fern, and it relates to Section 8 notices and confirmatory certificates given by corporate landlords. You may have noticed that the case reference is 2020 and wonder why it is featuring in a webinar on decisions from 2021. Well, I have two justifications for that. The judgment was handed down very late in 2020, just before Christmas, and also this case has now been further appealed, so I think it is worth including. The summary is that a Section 8 notice served by a corporate landlord does not have to be executed by the company in accordance with Section 44 of the Companies Act 2006 to be valid. However, a landlord's confirmatory certificate served under Section 213 of the Housing Act 2004 must be executed in accordance with Section 44 in order to be valid. The relevant statutory provisions are as follows. Sections 2135 and 6 of the Housing Act 2004 require a landlord who has received a tenancy deposit to give the tenant prescribed information relating to the deposit scheme in the prescribed form or a form substantially to the same effect. Article 21G7 of the Housing Tenancy Deposits Prescribed Information Order 2007 provides that the prescribed information includes a certificate signed by the landlord that the information provided is accurate to the best of the landlord's knowledge and belief. The form of Section 8 notice is contained in Prescribed Form 3 in the schedule to the Assured Tenancies and Agricultural Occupancies Forms England Amendment Number 2 Regulations 2016. And finally, Section 44.2 of the Companies Act 2006 requires documents executed by a company to be signed by 2 authorised signatories or a director and a witness. The facts here were as follows. A corporate landlord granted an AST to tenants in 2014. The confirmatory certificate relating to the tenancy deposit was signed by a director of the landlord. Subsequently, in 2017, the landlord served a Section 8 notice, and this was signed by the landlord's property manager. The tenant defended the subsequent proceedings on the basis that the Section 8 notice was defective, and they counterclaimed financial penalty under the Housing Act 2004 on the grounds that the certificate was invalid. And reliance was placed on the fact that the execution requirements in Section 44 of the Companies Act had not been complied with. At first instance, the County Court judge found that Section 44 did not apply to Section 8, but did apply to the confirmatory certificate. And as you have seen from the summary, the High Court judge agreed with that decision. Mr. Justice Saini considered a case called Hilmy and Associates Limited and 20 Pembridge Villas Limited, which was a decision from 2010 under the Leasehold Reform, Housing and Urban Development Act 1993. He took from this case the principle that you need to look at the document and the legislation which required signature to see whether the legislation required the company itself to sign or whether it allowed an agent to sign on the company's behalf. If the signature of the company itself was required, then this could only be effected in accordance with Section 44. And on that basis, the judge held that the Section 8 notice did not have to be signed by the landlord itself. Therefore, a corporate landlord was not required to execute the notice in accordance with Section 44 of the Companies Act. The judge commented that Form 3 expressly allows an agent to sign, and so it would be absurd if a director could not validly sign the notice unattested. However, the judge held that the 2007 order required the certificate to be signed by the landlord. There was a legislative decision to impose formality as to who could sign. Therefore, Section 44 applied and the certificate did not comply. The landlord had also argued that if the certificate as signed was defective, it was substantially to the same effect as one executed in accordance with Section 44. But the judge disagreed with that. Either it was signed or it was not, and in this case it was not. Therefore, the certificate was not valid. Now, this is a decision with considerable implications. The current state of the law does expose thousands of corporate landlords to potential claims for tenancy deposit penalties if the certificate has not been executed in accordance with the Companies Act. Also, if a corporate landlord signs a certificate as an initial agent, and this is not done in accordance with Section 44, the certificate is likewise defective. An appeal was heard by the Court of Appeal on the 18th of January, so just last week. So keep an eye out for the decision in the coming weeks. The case will be back in the news with consequences for the execution of documents by both corporate landlords and agents. My next case is Global 100 Limited and Waiver, and this case relates to the test appropriate for summary determination of a possession claim under CPR 55.8. The summary of the case is that the test to be applied when considering whether possession proceedings are genuinely disputed on grounds which appear to be substantial is the same as the test for summary judgment under CPR 24. The case also held that the principle of estoppel between landlord and tenant applies to a licence of land as between licensor and licensee. And there is also a useful discussion in the case of the lease licence distinction. As for the procedural background, CPR 55.8(1) and 2 provide that at the first hearing of a possession claim, the court may decide the claim, or where it is genuinely disputed on grounds which appear to be substantial, the court may give directions or allocate the claim to a track. The facts of this case were that the NHS entered into a licence agreement for property guardian services at empty accommodation with a company called GGM Limited. GGM entered into an arrangement with an associated company, the claimant, which then granted temporary, non-exclusive licences to guardians to occupy the property, and this was to ensure security and prevent vandalism. The NHS terminated the agreement and the claimant sought possession against the guardians, including the defendant. The defendant asserted that she occupied under an AST and the licence was a sham arrangement. She also argued that the claimant, licensor, did not have sufficient interest in the land to bring the claim for possession. His Honour Judge Lubercusi, on appeal from the district judge, held that the claimant did have sufficient interest. But he held also that the threshold for defending a claim under CPR 55.8 was a relatively low one. He placed emphasis on the word appears, and also the fact that CPR 55.7 allows a defendant who has not filed a defence still to take part in a hearing. So he was of the view that unless the defence was unarguable, the case should not be summarily decided. The Court of Appeal held that the summary judgment test was the appropriate one to apply, namely whether the defendant has shown a real prospect of defending the claim. Lord Justice Lewison said that a lower test would be a waste of resources and a higher test would be almost impossible to formulate. He said that a decision to make a possession order at the initial hearing is not a discretionary case management decision, and therefore it can be set aside on appeal if it was wrong. The court held that the defendant was in occupation as a licensee. The guardian services were similar to a service occupancy. And there is, as I said before, a useful discussion of the lease or license issue, and also the question of sole occupation without exclusive possession in the judgment. The court also found that this agreement wasn't a sham. There was no evidence that the claimant intended to create a tenancy, so the necessary ingredient of common intention that the arrangement was not to create the legal rights and obligations that it apparently did create was missing. And the court dismissed the tenant's argument that since a licensor cannot bring a claim in trespass, it follows that he cannot claim possession. Having accepted the licence from the claimant, the defendant was estopped from denying the claimant's interest in the land. The estoppel, which prevents a tenant from denying a landlord's estate in land, applies equally to a licensee. Well, this is a useful decision, in my view, for marshalling arguments for or against possession at that first hearing. I think the case will be of more assistance to landlords because district judges so often seem to give tenants the benefit of the doubt on a bare assertion of a defence. The summary judgment test requires that the defence must be realistic as opposed to fanciful. Is there substance to the tenant's allegations? And at a first possession hearing, in applying the CPR 24 test, the judge ought not to take what the defendant says at face value. The judge should test whether there is a real substance in the factual assertions that a defendant has made, and where possible, by reference to contemporaneous documents. Finally, I think that where only the amount of arrears is challenged, then possibly it will be easier to obtain possession at the first hearing with directions being given on the debt claim for rent. The next case moves us into the commercial context, and it is TFS Stores Limited and Designer Retail Outlet Centres Mansfield General Partners Limited. It relates to contracting out of the Landlord and Tenant Act 1954, and it's another case about completing a document. The summary is that a declaration or statutory declaration for contracting out of security of tenure under the 54 Act need not specify a calendar date for commencement of the lease. A formula for identifying the date or a date to be agreed is sufficient, provided that the declaration read as a whole is sufficient to identify the lease. The statutory background is that Section 38A of the Act provides an exception to the rule against contracting out in Section 38, provided that the landlord has served a notice in the form or substantially in the form set out in Schedule 1 to the Regulatory Reform Business Tenancies England and Wales Order 2003, known as the warning notice, and also that the requirements in Schedule 2 to the order are met. Principally, this means that the tenant must make a simple or a statutory declaration in the form or substantially in the form prescribed. and that depends on whether or not the warning was received at least 14 days before the tenancy is entered into. The prescribed form includes the wording, I blank propose to enter into a tenancy of premises at blank for a term commencing on blank. And this case concerns how the blank following for a term commencing on is completed. The facts were that there were 6 leases of retail premises, all containing agreement to exclude Part 2. Warning notices in the prescribed form had been served by the landlord, and all of the tenants had completed statutory declarations before entering into either an agreement for lease or a lease. Paragraph 1 of the statutory declarations had been completed, stating variously a date to be agreed between the parties, the access date under the agreement for lease, or for a term commencing on the date on which the tenancy is granted. The tenants argued that a calendar date when the term commenced was required. Therefore, these declarations were not in the prescribed form and the tenancies were not contracted out. And at first instance, the court held that the formulae were valid. This was confirmed by the Court of Appeal. All the formulae used were valid and the leases were contracted out. In the leading judgment, Lord Justice Males said that the purposes of the declaration were for the tenant to acknowledge that security of tenure was to be excluded, that the landlord had served the warning notice in proper form, and that the tenant had read it and accepted the consequences of entering into the lease. The purpose of paragraph 1 of the declaration was to identify the lease. So provided that it left no room for doubt as to the lease which was subject to the declaration, its purpose was fulfilled. And therefore the declarations were in the form or substantially in the form prescribed. Otherwise, the court said, contracting out would have become far more onerous, and it would discourage tenants from making early declarations when Parliament had clearly intended that declarations could be made at any time between the warning notice and the execution of the lease. And Lord Justice Arnold, in a concurring judgment, commented that there was no reason to treat the completion of the declaration as an exam question for the tenant. This decision is a victory for commercial common sense. Had it gone the other way, it would have been a case of having to leave contracting out until very late in the day if the date of completion of a lease was not known until a late stage. It could also have made contracting out almost impossible where the term commencement and or the completion of a lease were tied under the agreement for lease into the completion of works to the premises. It would have led to a flood of tenants claiming security at the end of their leases. As it is, however, it removes previous doubt as to how to complete paragraph 1 of the declaration, where the commencement date of the term is unknown when the declaration is given. So it is a good thing. My final authority is Fires and Burnley Borough Council, and this deals with waiver of forfeiture. The summary is that if, with knowledge of a breach of covenant, a landlord demands or accepts rent payable after the breach, there will be a waiver of the right to forfeit, even if the landlord had no knowledge of the breach at the date when the rent accrued due. By way of background, a landlord waives a right to forfeit if, after becoming aware of the breach, he does any act unequivocally recognising the continued existence of the tenancy. Now, a demand for and acceptance of rent accrued since the right of forfeiture has arisen is in both cases a waiver. But does a demand or acceptance of rent falling due after the breach, but before the landlord had knowledge of the breach, also amount to waiver? and that was the point considered in this case. The facts were that cafe premises were let by the landlord to the tenants. The lease contained a covenant for insurance rent, an absolute covenant against subletting, and there was a forfeiture clause. I've set out the dates on this slide because they are quite important to the sequence of events. On the 26th of September 2019, the landlord demanded insurance rent due on the 2nd of October for the period the 1st of April to the 25th of February 2020. In early October, the tenants sublet in breach of covenant, and the landlord became aware of this on the 18th of October. On the 30th of October, the landlord served a Section 146 notice. On the 4th of November, the landlord sent a recalculated charge for the insurance rent, which was revised to go up to the 18th of October only, and this was paid by the tenants on the 11th of November. On the 22nd of November, the landlord peaceably re-entered. The tenants sought a declaration that the landlord had waived the right to forfeit and damages, and they argued that there had been waiver by the demand and acceptance of the payment of insurance rent. At first instance, the court held that there had been no waiver, and the Court of Appeal dismissed the tenants' appeal. Lord Justice Lewison came to the conclusion that there was no binding authority on this point, as the various dicta referred to were not part of the ratio of the cases, and the textbooks gave differing views. He said that it was necessary to go to first principles. It is breach of covenant that entitles a landlord to forfeit, not whether or not he has knowledge of the breach. Therefore, it does not matter whether the rent accrued before or after the date of the landlord's knowledge, but whether it accrued due before or after the date of the breach of which the landlord now has knowledge. The critical thing is whether rent accrued due before or after the date of the breach, provided that the landlord knew that the breach had been committed when he demanded or accepted the rent. Therefore, where a landlord demands or accepts rent which accrued after the date of a breach known to the landlord, there is a waiver of forfeiture. In relation to knowledge, in the case of a unlawful subletting, Lord Justice Lewison said that the landlord must know that the subletting had taken place and that the rent demanded or accepted accrued after the date of the breach. And on the facts here, the tenants failed to discharge the burden of proving that the rent had accrued due after the date of the breach, and so no waiver was established. Well, clearly it's very useful to have a decision on this previously undecided point, but the case is also a reminder of the technicalities of the law of forfeiture and the need to analyse a situation with care before giving advice to landlords or tenants as to how to proceed where there has been a breach of covenant and forfeiture potentially arises. And finally, I would recommend reading the judgment of Lord Justice Lewison for the discussion it contains in relation to waiver. Well, that concludes my tour of authorities from 2021. I hope that you will find these cases useful in practice. Thank you very much for watching.